Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
This is Lindsay Smith Rogers. Today, Johns Hopkins legal expert Joanne Rosen joins Josh Sharfstein to look back on the recent court decisions on mifepristone, the drug used widely for medication abortion. Then they look ahead to what's next. Let's listen.
Joanne Rosen, thank you so much for joining me on Public Health on Call. We're here to talk about mifepristone and the Supreme Court. It has been quite a week, hasn't
it? It really has, yes.
Let's go back to where this started in a Texas courtroom, and then we'll talk about how it made its way to the Supreme Court.
Sure. So as we both know, the Dobbs opinion came down in June. And in around August of 2022, this organization known as the Alliance for Hippocratic Medicine, it consists of a group of anti-abortion medical associations and physicians incorporated in Amarillo, Texas, and then in November filed this claim, really an unprecedented claim in Amarillo, in which they were alleging that the FDA's original approval of mifepristone back in 2000 and then some of the FDA's subsequent decisions with respect to the availability and conditions around mifepristone were essentially, for a number of reasons, unlawful, and they were seeking the revocation of those approvals and therefore the removal of mifepristone from the market.
Now, they selected Amarillo not by throwing a dart at a map.
That's correct. Now, they've argued that they incorporated in Amarillo because they had some ties to Amarillo. But the way that the Northern District of Texas, the federal court, Northern District of Texas, works is that there are some locales in which there are only single judges assigned to those locales. And Amarillo is one of those locales with only a single judge. So if you file your case in Amarillo, you will get one judge. And this judge, Matthew Kacsmaryk, is very, very well known to be quite conservative. And prior to becoming a judge, prior to his appointment, he had worked for an organization well known for its anti-abortion and anti-LGBTQ positions. And so if you were a conservative group with a very strong opposition to abortion, and you were seeking a judge from whom you might get a very favorable hearing on an incredibly unusual type of anti-abortion claim, Amarillo and Judge Kacsmaryk might be exactly where you would want to begin.
Right. And lo and behold, they filed this pretty remarkable argument that a medication should be taken off the market after 23 years, despite a very strong safety record, the support of the Food and Drug Administration and all the major professional associations. And the judge agrees with them. The judge basically orders mifepristone off the market. Now, this is maybe a couple weeks ago.
Yes, a lot has happened in a very short time. That was on April 7th. And Judge Kacsmaryk's ruling in this case was what is known as a preliminary injunction, or in his case, he ordered a stay, a preliminary stay. So he has yet to hold the full trial on the merits and issue a determination. But one of the things that made his stay even more extraordinary was this was a stay that would be in effect pending the hearing on the merits and the opinion. It's extraordinary because, for many reasons, but usually one of the reasons a plaintiff will seek a stay is that there is some new rule that hasn't yet come into effect but will. And while the litigation over the legality of that rule is going on, the plaintiffs may say, can we stay the rule? Because this rule threatens to upend the status quo and cause irreparable harm. In this case, the status quo was that mifepristone has been available, used by more than 5 million women. As you say, numerous studies have shown that it's safe and effective. So the issuing of a stay at this preliminary point prior to a determination on its lawfulness, it itself upends the status quo dramatically. So that was just one of the reasons that this was really an extraordinary decision. I can tell you more if you want, but that, just on the technicalities of when a stay is issued, was really thrown on its head in this case.
It wasn't the only remarkable thing about this opinion, because it really didn't read like a lot of opinions. And even though I don't read opinions that often, I was impressed with the language that was used. It was pretty extreme rhetoric. The reference to websites with testimonials as scientific sources, sort of the dismissive approach to the enormous amount of scientific information, the views of major, scientific bodies. It read to me like someone who had a ideological opposition to abortion and was just throwing everything that they could at the wall to argue that mifepristone should be taken off the market. Was that unfair, you think?
No, I think that's completely accurate. The rhetoric that was used in the opinion is really not what you see. So you've read some opinions. I've read many, many, many opinions. This opinion is not written in the language of the law. It is written in the language of ideology. The terminology to refer to an embryo or a zygote or a fetus was abandoned in favor of unborn baby or unborn human. And in fact, the very first footnote to Judge Kaczmarek's ruling is an explanation for why he believes that referring to the fetus or fetal life or embryo is inaccurate and that it should be unborn human or unborn baby. You're correct. One of the tests for issuing a preliminary stay is there a reasonable likelihood of success on the merits when we finally get to the trial? And that's why Judge Kaczmarek went to look at the scientific evidence with respect to the safety of mifepristone. He didn't look at the numerous studies that the FDA had considered. He went to look at, as you adverted to, other highly unusual studies. One of them had to do with an article based on a blog, an anonymous posts, 54 anonymous blog posts to a website operated by a pro-life organization called Abortion Changes You. This would not, for those of us who practice in the realm of science, of best practices, of epidemiology, this would not be something we would even look at. But this was one of a very small number of, I'd say, outlier type of studies that Judge Kaczmarek relied on to reach the conclusion that mifepristone is harmful and puts the lives of girls and women at risk. And he also included in his analysis of irreparable harm, the harm that mifepristone does to the unborn human. So yes, it was not steeped in the language of the law at all.
So the decision comes out, and it is held for a few days to give the Court of Appeals a chance to weigh in. And the Court of Appeals comes in with a different ruling. Can you explain what the Fifth Circuit did?
Sure. And you're correct. Judge Kaczmarek put his order on hold for 7 days to allow the FDA and Danco to appeal. The Fifth Circuit said that they allowed part of Judge Kaczmarek's stay to continue, and they removed part of the stay. What they did was they said that the FDA's initial approval of mifepristone back in 2000 was allowed to, they rolled back the clock, in effect, to the status of FDA approval of mifepristone back in 2000, and the subsequent decisions that the FDA made in the years following, which adjusted the dosage of mifepristone to what evidence showed to be a more effective dosage, which was actually a lower dosage. They reduced the number of in-person medical visits from 3, which was required in 2000, to 1. The FDA subsequently allowed advanced practice clinicians other than physicians to dispense mifepristone. That was subsequent to 2000. They allowed for the mailing of mifepristone. The Fifth Circuit said all of those decisions by the FDA with respect to how mifepristone could be available after 2000 were going to be stayed, and the terms of the original 2000 approval were in force. And that created, I think, the veneer of, oh, this doesn't seem so bad. But actually, in practice and in reality, was a dramatic constriction on availability of mifepristone that also created a great deal of confusion about what would or wouldn't be required. For example, would physicians have to go back to the higher medically unindicated dose? Would 3 visits be required? And so on.
On top of that, I certainly heard a lot of confusion about the generic version of mifepristone, which is actually the majority of the market because it had not been approved back then. And so there was a question of whether it could even be offered. So the result of that Fifth Circuit decision, as you said, was not actually to calm the waters, but actually to throw things up in the air. And there was a lot of concern about massive disruptions in care.
Yes, as you said correctly, in 2019, the FDA approved a new drug application for a generic form of mifepristone, and that is in use more widely than the brand Mifeprix that was approved in 2000. So that was really unclear whether all of the generic would no longer be available. And then there were concerns about whether currently the label on mifepristone reflects the changes to the FDA's decision. So would they then have to relabel mifepristone in accordance with the FDA approval in 2000, which could take months to do, the relabeling? So there were a lot of legitimate areas of real confusion as a result of the Fifth Circuit change to the stay.
But that decision didn't go into effect because then the Supreme Court stayed the decision and said, hold on everything. This was at some point in the last week or two, and then everybody held their breath for what the Supreme Court was going to do.
Yes, that's correct. So the FDA, through the Department of Justice, brought an emergency application to the Supreme Court asking the Supreme Court to stay Judge Kaczmarek's ruling. And the Supreme Court, and again, I'm with you about forgetting the exact days. I know it was a Friday. The Justice Alito, who is the judge that reviews emergency applications from the Fifth Circuit, he put into place a temporary administrative stay so that the question of the stay that was being sought by the Department of Justice could be referred to the full court for review. And that temporary administrative stay was due to expire this past Wednesday at 11:59 p.m. Still no decision by the Supreme Court. Justice Alito extended the administrative stay until this past Friday at 11:59. And then this past Friday at around 7 p.m., the Supreme Court issued a brief unsigned opinion in which they said they granted the DOJ and Danco's full request for a stay. As you indicated, Justice Thomas and Justice Alito, or as we discussed earlier, Justice Thomas and Justice Alito both registered on the record their disagreement with this. But we now have a stay in place, and the terms of the stay are along exactly the lines that the Department of Justice sought, that mifepristone will continue to be available without judicial restrictions until the litigation brought by these plaintiffs has fully run its course, even if it gets so far as to get to the Supreme Court. So the confusion and the urgency around whether mifepristone will continue to be available during the life of the litigation has been settled by the terms of the stay that the Supreme Court granted.
So let's talk about the stay for a minute, and then let's talk about the overall litigation. But Let me just say, reliving the last couple of weeks as you were talking, it reminded me of my late grandfather, who used to refer to stressful situations as US, an ulcer session. I felt like this whole thing was an ulcer session because they kept postponing when they were going to say something, and it really left an enormous amount of uncertainty for a major medication used by a lot of people in reproductive health care. So it was a really stressful week for people, and it was late on Friday that decision came out. But in the end, like you said, the Supreme Court allowed things to stay as they are in practice while
Yes.
this case plays out. Did that surprise you?
Yes and no. If the issues in this case had involved anything other than an abortion-related issue, I think there would have been very little doubt among lawyers and legal commentators that the court would grant the stay on exactly the same facts if we took abortion out of the picture. But when abortion is part of the litigation, it's harder to call. When the court actually, in this case, the number of legal and constitutional errors or frailties in Judge Kaczmarek's order and then in the Fifth Circuit's order should have made it really straightforward that the court would grant a stay. In the end, when they did, and I could step back a bit and realize this is, what would have been more extraordinary is if the court had denied the stay and allowed mifepristone to remain off the market or deeply restricted while on the market. The thing that did surprise me, I would have to say, is that there were only 2 justices that put their disagreement on the record. That was surprising. I thought it might be a 6-3 or a 5-4. So that part did surprise me.
And again, you're referring to Judge Alito and Judge Thomas that who both said they disagreed.
Yes. So Justice Thomas expressed his disagreement on the record, but didn't file an opinion expressing his dissent, and he didn't join Justice Alito's dissent. Justice Alito wrote a short, it reads to me as a very angry dissenting opinion expressing why he disagreed and would have denied the stay.
So now we go back to the trial court in Texas, is that right? For further consideration of this lawsuit?
Almost, but not quite. This goes to how quickly things developed and how complex they were in a short period of time. The FDA and Danco, after Judge Kaczmarek ruled on April 7th with his preliminary stay, they brought an immediate appeal to the Fifth Circuit of the preliminary stay. And they also asked the Fifth Circuit to block Judge Kaczmarek's stay while they appealed the stay. And that the Fifth Circuit refused to block the stay, but they modified it, as you and I have just discussed. Now the matter goes back to the Fifth Circuit, and the Fifth Circuit will hear FDA and Danco's appeal of Judge Kaczmarek's decision about the stay. So we're still not on the merits. They will be going to the Fifth Circuit for their appeal of the ruling with respect to Judge Kaczmarek's stay. And the Fifth Circuit had said they would expedite the appeal, and they've set it down to be heard on May 17th.
So we're going to start to get some more decisions, and it may well go back to the Supreme Court even before the end of the spring.
So I think it will go back to, I think it's likely it will go back to the Supreme Court. Either side, whoever loses, will likely want to seek review by the Supreme Court. But I think that for the moment, the urgency and the speed with which this will proceed is not going to be the same as what we've had so far. Because the Supreme Court has put a stay in place of Judge Kaczmarek's opinion that will run all the way through to the end of the litigation, there will not be the same urgency for the Supreme Court to have to decide whether they will grant review of any petition for certiorari or not. They could, if they wish to, deal with this in sort of the ordinary course. And that's because we've had 23 years of mifepristone being available. We know that it's safe and effective, and the strength of a case around whether retaining the status quo would give rise to irreparable harm is simply not there. So I'm hypothesizing that there may not be nearly the same sense of urgency, and let's do this as quickly as possible going forward as there has been to date.
But what about the ultimate outcome? Do you think that the fact that it appears that 7 judges supported a stay means that 7 judges will likely support continuing to allow mifepristone to be sold as it has been? Or do you think it may be a little hard to predict the Supreme Court?
I think it's hard to predict. the court has said that the position they take on granting a stay should not be understood to reflect the position they may take should the case actually get to them. And it's gone both ways in the past with other stays. Sometimes their decision reflects a determination that the rule should be allowed to go into effect or not. So we don't know. But here are some things that I think make this an unusual case. And again, where it's abortion, as I said before, I'm always hesitant to try to determine what the outcome will be because it tends to be kind of like a monkey wrench. But as you have written, as you wrote in your op-ed in the New York Times, the FDA has rigorous, detailed, lengthy processes for reviewing new drugs and for revising its decisions with respect to drugs. What the FDA did with mifepristone is squarely within the scope of their authority. They bring their expertise to bear. It would be, and this would be the first time if the Supreme Court were to agree that Kaczmarek or the Fifth Circuit could revoke or revise FDA approval. This would be the first time, I believe, in history that a court has abrogated a decision about the safety and effectiveness of a drug over the objection of the FDA. So this may be so different from other cases involving abortion. There's also a really huge threshold question about whether the plaintiffs in this case have legal standing to bring this claim in the first place.
I'm sensing, maybe in your words, the teeniest bit of optimism that we will have a decision in line with the stay, but recognizing that we don't know for sure. And there are multiple opportunities, as you're saying, for the justices not to have to take a unprecedented action that would be really shocking for not just this particular medication, but for the whole regimen of drugs. But we're going to have to wait and find out. And in the meantime, really appreciate your joining this podcast, and we will check back in with you as this case proceeds.
Thanks so much. And I hope we have at least a bit of a stay on the ulcer sessions for a while.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmond. Audio production by J.B. Arbogast, Holly Cardinale, Philip Porter, Spencer Greer, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Fernandez and Shian Briscoe. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.